Hi, everyone. My name's Amy Schweikart. I'm from the North Suburban YMCA. It's my pleasure to welcome everyone here to our talk. It's called Estate Planning 101 with Matt Margolis. He's an elder law attorney and has been a wonderful member of our community, offering lots of insightful advice. And yeah, so the YMCA series is free and it's open to the public. As a nonprofit, we're always happy to take donations. If you find this event to be useful and helpful, please feel free to check us out on our website and to check Matt Margolis out as well. So with that being said, thanks, Matt, and I'll let you take it away.
Sounds good. Thank you, Amy.
Yeah.
Good to see those of you who are brave enough to show me your faces this morning. So yeah, I've been doing these talks for quite a while. As Amy said, my practice. So I'd say estate planning and elder law, which is really what the crux of our practice is. What that means is we do a lot of wills and trusts and powers of attorney, and then we kind of look at a lot of things really through an elder law lens. So we work with a lot of folks that as they're aging, there's just different considerations that they might want to think about what they're planning. It might be different ways to plan, whether we're using trusts or wills. Maybe we're discussing asset protection. Maybe we're helping discuss Medicaid or any kind of long-term care benefits, or simply just getting the right plans in place. So, we help everybody from the age of 18 putting powers of attorney for college kids going off to college all the way to, clients in their 90s and triple digits. So, yeah, that's a little bit about us. My office is in downtown Park Ridge. I'm a Northbrook resident. I actually live right by the YMCA, and I've been doing these talks pretty consistently since I think about 2016. I think it's been about 8 years now, which is crazy. And once upon a time, they used to be in person, but now we can all tune in from the comforts of our own home, and that's not a bad thing necessarily. So today is, my talk. I kind of call it Estate Planning 101. Trusts aren't just for the Pritzkers. I feel like I always say this. One time I gave this talk at the North Shore Senior Center, and there was a relative of one of the Pritzkers in the audience. So that was fun, based on my title. I think she was flattered, but I'm not sure. I'll just remember it that way. It makes me feel better. So the goal of today really is sort of what it sounds like, right? I mean, estate planning 101, estate planning for dummies, but I don't mean it like that. But it's really just, a lot of people have ideas of what these documents are when it comes to wills and trusts, and I think there's just a lot of that people don't know, a lot that people don't understand. They sort of different misconceptions surrounding what a will is and what it does, what a trust is, who a trust is appropriate for. And so hopefully at the end of this talk, you guys will leave with a little bit more knowledge than you came in with. And if there's any questions, my computer is kind of being a little bit difficult this morning. And so I'm not going to have a super easy time accessing the chat. Rely on Amy
Yeah, I can let you know if
if you're
anything.
able to email me anything from the chat.
Sure.
I've got my emails up right in front of me, but it's just my computer with Zoom right now is being weird, so I have to
Okay.
Zoom on my phone.
No problem.
So yeah, please, if you have questions, because I can't see everybody the way my phone's formatted, please put your questions in the chat box, and Amy can email them to me, and then that way I can answer them either while we're going on, or I might have to wait until the end depending on what the question is. I would just ask that any questions you ask are more general in nature. I really prefer not to take any personal questions during this. Those you want to shoot me an email, feel free, and we can kind of figure out how to get those questions answered in that way, depending on the question. But all right, enough of that. Enough of those housekeeping matters. Let's jump in. So when we look at planning, there are really two main paths we can go down. We have the will, and we have the trust. And I think at the end of the day, a lot of people are more familiar with the concept of a will. Whether they actually know what the will does or not is another story. But the idea of the will is something more people are familiar with. And I think that's just because that's even people that have trusts in place will refer to them as a will. They'll be like, oh yeah, my will. And then they come in and to the office and we sit down to review what they have. And, lo and behold, they actually have a trust in place. But saying a will is just more commonplace, right? It's more of that household term. And that's because, grandma had a will or grandpa had a will, or, if you're my father-in-law, you're always threatening your kids that you're going to take them out of your will. I joke. I mean, kind of. So, it just becomes that document that we're familiar with. And, I think a lot of people have this idea that a will avoids probate. And, we'll find out today that it doesn't. All right. So I guess I'm just breaking it out of the gate right now. A will does not avoid probate, but so many clients we meet with think that it does. And so many clients also have this idea or this notion that trusts are just for rich people, right? Trusts are just for the Pritzkers. And that's not true either. All right. And I can tell you right now that probably this, I mean, things have changed, but I would say probably about 80% of the clients that we work with where we're putting a trust together, we're not doing so because they have a taxable estate, because we're trying to avoid paying estate taxes to the state of Illinois. We're putting a trust together simply to avoid probate. Okay. And so again, I'll get into this in a little more detail, but I just want to throw those things out there in the beginning. I think they're really important to understand. Very important to understand that wills do not avoid probate, and trusts are not just for those who are wealthy, whatever that means, right? And we all have different definitions of that based on, maybe how we were raised, where we live, all of those things. So let's sort of use me as an example here, right? At some point, I'm going to pass away, right? I hate to admit it, but I will. And, the question becomes, where is my stuff going to go when I pass away? And who's going to get it? And how is it going to go to them? And so, ultimately there's a process in Illinois where a judge will determine where my stuff goes and who will get it and how it will go to them. And that process is called probate. Okay. And, the reality is, in some cases, our estates will go through probate, and in some cases they won't. And it really just depends on what type of planning we did. Okay. But ultimately, there is a solution, whether we've done planning or not. And that is the probate process. Okay. The reason why we go through probate, and I don't care if you have a trust or a will or what kind of planning you've done. Okay, so the idea of going through probate can happen, or going through probate, I should say, can happen no matter what type of planning you have done or not done. Here is why we go through probate, or here is why somebody would go through probate. If at the time I pass away, I have assets in my name only that are not, so they're not owned jointly with somebody else, and they don't have beneficiaries on them, they will go through probate. It does not matter if I have a will that says everything goes to my kids equally. It does not matter if I have a trust that says everything will go to my kids equally. If I have assets in my name only that are not owned jointly with somebody, and I should obviously say jointly with somebody that's alive, right? So if my wife was joint on the house, but she predeceased me, that doesn't count. I hope hope everybody's on the same page with that. So if I have assets that are in my name that are not owned jointly with anybody and that do not have beneficiaries listed on them, and I will say those assets have to exceed $100,000. If they're under 100,000, then there's ways to avoid probate. I'm not going to get into all the details of that. But if you own a house, you're going to fall into this category unless your house is somehow worth less than $100,000, which I highly doubt. But with real estate in general, it doesn't matter. Real estate will go through probate. So assets in my name only, no beneficiaries, not owned jointly, they'll go through probate. Doesn't matter the type of planning you've done. Okay, now we're not going to talk about the trust for a while. But again, let's say I had a will, right? So I had a will in place, and my will said everything goes to my wife if she survives me. And if my wife doesn't survive me, everything goes to my 2 kids in equal shares. And if my wife survives me, she will be the executor of my will. The executor is who I'm naming to administer my estate, right? Who's going to manage my estate when I die? right? And if my wife doesn't survive me, then the executor is going to be my brother. And if he doesn't survive me, the executor is going to be my best friend, right? So I can name as many executors as I want. I can name them one at a time in order. I can name co-executors to act together. Okay. So I want to make sure, first of all, we understand the difference between a beneficiary and executor. A beneficiary is who we're leaving our assets to, right? Who is going to inherit from us. And an executor is who is going to administer our estate. It can be the same people. It can be the same person. Very commonly, it's the same people, because a lot of us that are married, typically our spouse is going to be our first executor, and they're also going to be our primary beneficiary. Now, for those of you that might have adult children, right? I don't, but for those of you that have adult children, it's also going to look fairly similar, because you're probably naming your spouse first as executor and beneficiary. And then if your spouse doesn't survive you, in a lot of cases, I won't say all of them, but in a lot of cases, my clients will end up naming an adult son or adult daughter or both of them together as their executors. And then they will also be the beneficiaries, right? Because if your spouse doesn't survive you, most of us tend to go to our kids next as far as who we want to leave our stuff to. More common than not, right? There's obviously always exceptions. And so executors and beneficiaries can be the same people, but they still, we will actually put them in different roles. Okay. And so again, even in this example where my wife is my beneficiary, and let's use the example that she passed away before me. Let's say my kids are not my beneficiaries. Even in this situation where they are named as my beneficiaries in my will, if the house is in my name only when I die, it goes to them. It goes through probate. If my brokerage account at UBS is in my name only when I die, it's going to go through probate before it goes to my kids. Okay. Now, the way that we avoid, or the way that a lot of people can avoid probate, okay, way that a lot of people avoid probate, at least I'm going to say with married couples, the way that we avoid probate, or the way that people will avoid probate, normally up until the first spouse passes, is sort of by default, right? It's not really that most couples were like very much thinking like, oh, we put this plan together, but a lot of married couples, not all, but a lot of married couples tend to own things jointly, right? So my wife and I, before we did our planning, our condo was in both of our names jointly. Our checking and savings accounts, our brokerage accounts were in our names jointly. The only assets that were in our names individually were our retirement accounts. So my IRA and my wife's 403B and our life insurance policies. But we were beneficiaries for one another on those. So the reality is, whether I had a will or not, or did any planning at all, if I died at that time without doing any planning, everything would have gone to my wife because she was either a joint owner or beneficiary. So a lot of married couples can sort of get away with doing no planning up until the time the first spouse dies. Now, my disclaimer here is I am absolutely not suggesting that any married couple here does not do any planning, simply because of what I just said. I'm just saying that fortunately, some can get away with doing no planning. And that's definitely not all, because not every single married couple owns everything jointly. Not every married couple has the correct beneficiaries designated on their accounts. I've seen various situations over the years where people thought they had certain things and found out that they did not. If the estate goes through probate, probate, while I would definitely say it's not ideal. I don't think anybody is going to say like, oh, I would be fine if my estate went through probate. That's not a phrase that people use. I'm not going to say it's terrible, but probate is definitely not ideal. Probate in Cook County, which is where we do most of our work, and we don't do a ton of probate cases, but we only take on simple probates. Simple probates meaning, somebody passed away, they're leaving their money to their children equally, or maybe to their nieces and nephews or whatever. A simple probate meaning, maybe there's 5 to 10 bank accounts, there's a piece of real estate that has to be sold, and all the beneficiaries get along. Okay. For a simple probate, you're probably still looking at about, I would say for sure, no less than 14 or 15 months in court. And it could be up to 2 to 3 years. This is for a simple probate. And you're probably looking at somewhere, fees somewhere in the range of, I would just say it could be, depending on the attorney's hourly rate, probably anywhere from about $4,000 to $4,500 on the low end, upwards of $10 or $11 or $12,000. Now, this is definitely an average range that we see for the more simple cases that we take on. There are definitely more complex cases where there's way more assets out there, way more bank accounts and investment accounts that have to be dealt with. Various parcels of real estate. Maybe there's real estate in other states that has to be dealt with. Okay, so every situation is different, and so they can definitely cost a lot more money and take a lot more time. But what I'm giving you is sort of the average. Okay. The way that we would avoid probate, okay, the way that we typically look to avoid probate is going to be through the use of a trust. Okay. And before I get there, I just want to be clear. A will is a planning tool that makes sense in certain situations. Okay. Because I think when I start talking about the trust, I think you're going to maybe you might notice some bias on my part. And that's just because I would say that trusts do make sense for quite a few people these days. Okay. Realistically. And I think you'll all understand why when I start talking about it, just to be realistic with everybody. Wills do make sense for some people, right? But typically when we're putting a will together, just so we're all on the same page, because that will is not going to avoid probate, we might be using the will because we want somewhere to name guardians for our minor kids. So if we've got minor children, the will is the only document that we use to name guardians for minor children. Okay. But also maybe I'm working with a client and he or she rents an apartment. They don't own real estate. Maybe they've got a bank account with, $50,000 in it and an IRA with $200,000 in it. And they've got 2 kids. It's not a very complex estate. We might say, yeah, will make sense, right? You're going to say everything goes to your 2 kids equally. You might make discuss some distributions of some personal property that you have that you want to go to your kids or grandkids. But the reality is that the way that your bank accounts and your IRA are going to get distributed, it's not going to really be through the will. You're going to do that through beneficiary designations, right? You're going to name your kids as beneficiaries on the IRA. You're going to name them as beneficiaries on that Chase checking account. Okay. And the will is just going to be there as a backup. God forbid if something slips through the cracks. And I also want to be very clear that a beneficiary designation on an account or joint ownership of an account completely supersedes language in a will. Let me give you an example. I say in my will, everything goes to Amy here, who's hosting this from the YMCA, right? My will says everything goes to Amy. However, my wife is joint on all my accounts, and she's beneficiary on all the accounts that we're not joint on. When I die, everything goes to my wife because the joint ownership and the beneficiary designations supersede the language in my will. Okay. I would assume that would have been clear, but just to make sure, okay, just to make sure you all picked up on that. Okay. So we now look at the idea of a trust, and a trust on its face looks very much like a will, right? It talks about who's in charge of our estate, but with a trust, that's a trustee, not an executor. Okay. It's called a trustee. Similarly, who's going to get all our, my stuff when I die? Same thing. Those are my beneficiaries, right? And how are they going to get it? And we'll go into that. So in a lot of respects, the documents look very similar, but they operate very differently. A will, if it wasn't clear, only kicks in when I die. A will literally does nothing for me during my lifetime. All right. It's not really like a living, breathing document, we'll say, right? It kind of sits dormant until I'm dormant. And then it comes to life. If you kind of look at it that way. Whereas a trust, and the type of trust we'll talk about today is what we call a revocable living trust, because there's different types of trusts out there. So I want to be very clear, the type of trust, I'm going to just use the term trust, but just so you know, it is a revocable living trust. A revocable living trust, this is what we're talking about. Or a living trust, you maybe heard that term before. This is the most common type of trust. Okay, if you have family members or friends or somebody that has a trust, I can just about guarantee it's probably a revocable living trust, probably 95%. Okay. The revocable living trust is flexible. That's why people like it, meaning I can make changes to it over time. All right. So something in my life changes as long as I have capacity, right? As long as I'm still good up here, I can still make changes to the trust. If I lose capacity, well, the trust is now irrevocable and I cannot make changes to it anymore. Also, the trust operates off my social security number. So when I have a trust in place and I retitle my assets to the trust, and I'll talk about what that means shortly, my taxes don't change, right? I'm not like being kicked into a different tax bracket. I don't file my taxes any differently. Literally, as far as the IRS is concerned, I don't have a trust in place, right? They don't care. It means nothing to them. The trust is just an extension of me for tax purposes, to be clear. Okay, again, this type of trust that we're talking about, different trusts can work differently. Okay, so nothing in my life changes. All right, so I create this trust. And if I'm married, I might create a joint trust, right? My wife and I might create a trust together. And I'll talk about, the idea of creating a joint trust with a spouse and two different trusts, and it kind of just depends. But when we're creating a trust, the person that's creating it, so if I'm creating it alone, or if I'm creating it with my wife, whoever's creating it, I or we are called the trust makers. Some of you have maybe heard the term grantor, maybe you've seen the term on a trust or a will. Grantor, settler, trustor. Everybody uses their own term. We use the term trust maker. Sounds like exactly what it is, right? We're the ones making the trust. All right, the trust maker or trust makers are the only people that can actually make changes to the trust. Okay, so if it's my trust, I'm the only one that can make changes to it over time. If my wife and I are both trust makers, not co-trust, both trust makers, if we have a joint trust, either one of us can make changes to it over time. Okay, if we're both alive, we both need to agree to the changes. If one of us passes away, typically the way most joint trusts are drafted is that the survivor can still make changes to the trust. Okay. So my wife and I create this joint trust. We are the trust makers. All right. We are also going to be the trustees. All right. Now this is a little bit different because with a will, you can't be the executor of your own will. But that should make sense, right? Because the will doesn't kick in until if you guys are all here in person, you would all say die at the same time, right? So the will doesn't kick in until I die, and so the executors don't kick in until then. And so I can't name myself as my own executor. But with a will or with a trust, I'm sorry, if it's my trust, or in this example, my wife and I are creating the trust together, we are going to be both trustees. We are going to be co-trustees. Okay, and if it's just my trust, then I will be the sole trustee. Okay. The trustee is the person that can manage the assets that are in the name of the trust. Okay. Now let's talk about that. And I'll get that there. I'll get there in a second, actually. Okay, the trustee is the person that can manage the assets in the trust. Now I'm also going to name successor trustees, right? Because at some point, I won't be able to be a trustee. We know I'll die for sure. I might be incapacitated prior to that. Right. So if my wife and I are co-trustees, well, something happens to me, then she'll still be the sole trustee, and vice versa, right? Something happens to her, I'm the sole trustee. But something happens to both of us, whether we're both deceased or one of us is deceased, the other one's incapacitated. But if we're both in a situation where neither one of us can be the trustee, then we need successor trustees. Now you can kind of think about the successor trustees as like the executors of a will. Okay, a little bit. However, that successor trustee might step in while we're still alive. Because remember, the trust is a living, breathing document from day one. So if I'm dead, but my wife is alive but incapacitated, then that first successor trustee, let's say it's my father-in-law, then he steps in and he can manage the assets in the trust for the benefit of my wife. Okay. And we can name as many successor trustees as we want, just like naming executors in a will. We can name co-trustees. It doesn't matter. I always say when naming trustees and when naming executors, the more the merrier, as long as they're people that we trust. No pun intended. Some clients have a real struggle naming people, right? Maybe they don't have kids. They're not close with any of their nieces and nephews. Their siblings are as old as they are, and maybe they're at a point in their life when they're a little bit older, and their siblings might not be as helpful. Maybe they're in Florida or Maine or California. Some situations I've got clients, they've got like 5 or 6 people they can name as trustees or executors. So for some people, it's really easy. For some people, it's not easy at all. Planning can be very difficult for some people. Planning can be very easy for others. It's something that I have to always remember when I'm working with clients, right? Because, to me, I talk about this kind of stuff every day, but we all have to realize that, even though we do something every day, not everybody does, and things can be difficult for other people. But I digress. So when we talk about trustees, we can name as many people as we want. Great. Let's talk about what I said a second ago, though. The trustees are the ones that can access and handle and deal with all the assets that are in the trust. Well, let me explain how we avoid probate with a trust. It's not good enough to just put a trust in place. right? So let's say, client comes into my office, we put a trust in place, and they walk out, and they never retitle any of their assets into the trust, right? Now we will always retitle real estate for clients, right? So their homes will always be in their trust. We know that. But let's say they don't take my recommendation of sitting down with their financial advisor at Wells Fargo and retitling the brokerage account from the two of them jointly to their trust, or their bank accounts at Bank of America to their trust. At the time they pass away, the house avoids probate because the house was in the trust, right? The IRAs and the 401ks had beneficiaries on them, so those avoided probate. But that brokerage account at Wells Fargo with $250,000 in it, that's going to go through probate because it was in their names only. They never retitled it to the trust. They never sat down with their financial advisor and said, hey, Matt gave us this nice long list. Matt, this wonderful attorney, gave us all this great advice and was very clear about what we should do. And we just never came to sit down and talk to you about it. So the way that we avoid probate with a trust is that we actually have to retitle our assets to the trust. Okay. This is super important. All right. I've met with a financial advisor months ago, and she said this to me, and I wrote it down, and it's sitting right at my desk. And she said this is what she tells her clients that put trusts in place that don't put their assets in it. And the phrase that we use is they don't fund their trust. And she said, you just built that garage, but you're still parking your car outside. And I really like that. I think it really hit home for me because it's true, right? It's like you just went to the attorney. You just spent this time, you spent this money. You have this plan that can help you, but you're still doing things like you don't have it, right? So we have to. So I can only say what we do as a law firm. I can't speak for other law firms, right? So what we will always do for clients when we put trust together, if they have real estate in Illinois, we will retitle it to their trust. We'll record a deed with Cook County or Lake County or DuPage County or wherever they live, and now their house is in the name of the Matt Margolis Trust. And if they have a house in Michigan or Florida or California, first of all, hopefully they'll let me stay at some point. But outside of that, if they have property in other states, then we will work with an attorney in that state and have that attorney help us prepare a deed and record it and retitle that property into the trust as well. So we will always help with the real estate, like physically, right? We will do that or coordinate getting it done. But as far as like the bank accounts and the investment accounts and the brokerage accounts and the IRAs and 401ks and life insurance policies, we don't physically do that. Okay. If clients want to pay me extra money to do that, I'm happy to, but it's not necessary. They don't need to. So what we'll do with clients is and listen, every attorney has their own version of this. I'm giving you our version. It's the only version I know. Right. But we'll go through and we'll make recommendations about, okay, you have to go to Bank of America and retitle that checking account to the trust, retitle the savings account to the trust. When it comes to the brokerage account, all right, so not IRAs, but like the brokerage accounts at the Wells Fargos or the UBSs or the JP Morgans, that needs to be retitled to your trust. Now, when it comes to life insurance policies and IRAs, those are different. We're going to use beneficiaries on those. And the beneficiaries may or may not be the trust, right? In most cases, with a spouse, our spouse will be the primary beneficiary on those types of accounts. For the most part, definitely always with a retirement account, an IRA, a 401k, a 403b. A spouse will always be the primary beneficiary. And then in some cases, our kids might be the contingent beneficiaries. In some cases, the trust might be the contingent beneficiary. But IRAs and 401ks don't get retitled to a trust. Those stay in our names. We're just going to make sure that we update the beneficiaries appropriately. Life insurance policies, same thing. Life insurance policy will stay in our name, but we're going to make sure that we update the beneficiaries on them. And it might be the spouse, might be the trust directly. Okay, just depends. Every situation is a little bit different. But this is how we avoid probate, guys. Okay, it's not just putting a trust in place; it's actually retitling our assets. And so now that the assets are retitled to the trust, nothing changes, right? Like I said before, we file our taxes the same way. I tell my clients the only change that you're going to see is that when you get that statement from Bank of America on the top left corner, instead of saying Matt Margolis and then your home address underneath, it's going to say the Matt Margolis Trust, dated October 1st, 2024, Matt Margolis trustee, and then your address underneath. That's it. It's the only change. And now if something happens to me, whoever that successor trustee is, they can step in and they can have access and deal with all the assets now that are in the name of the trust already, right? The house, the bank accounts, the investments, etc. All right. Now, when we talk about, now let's talk about beneficiaries. Sorry. right? So where's all my stuff going to go when I die, right? And how does it go to them? Well, most of us that are married, if we have a joint trust, sort of the default is that when I pass away, the trust just kind of stays for my wife's benefit. And if she passes away, that kind of just stays in place for my benefit. But then when the second of us dies, right? So for us, everything goes to our two kids equally, right? And everybody has their own version of that. I'm just speaking what my version is, obviously, but you can kind of think about what your situation is. Everything goes to our two kids equally. Okay, great. How does it go to them? Right. And so this might be different depending on who we're leaving money to. And of course, you can leave money to, to charities. It doesn't have to be individuals, right? You can leave money to various organizations, people, etc. But when we're leaving money to people, there's two different ways we can leave them money. We can leave them money outright, meaning let's just say there was $500,000 when my wife and I pass away after all the expenses and et cetera are paid. Right? There's $500,000. Well, the trustee, let's say the trustee is my brother. He cuts each of our kids a check for $250,000. They can do whatever they want with it. Okay, that's what we call it, or what we refer to as an outright distribution. Right? They get it outright. The other option is that we might leave our beneficiaries money in trust. Right. And now this is maybe what we've heard over the course of our lifetime that's made us think that trusts are just for, quote unquote, rich people, right? For the Pritzkers, because we probably heard this term trust fund baby or trust fund kid. Right. And I think this is why I forgot to say this earlier. I normally say it earlier, but this is why I think a lot of us have this idea that trusts are just for rich people or wealthy people. Because we've heard through friends that we went to, friends of ours from college or high school that were trust fund kids, or, we see it on TV or in movies, it's just, it's been around us. Right. I mean, and so we're led to believe that trusts are just for wealthy people. And so now, my wife and I are going to create two trust fund kids, right? This is just how we're leaving them the money, right? We're not wealthy. It's just the way that we're leaving them the money. And the reason why we would leave money to beneficiaries in trust is either because of their age, right? We want to make sure that yes, the money's there for their benefit, but we don't want them to have access to it until they turn a certain age where we think and hope they will be responsible. Or B, maybe it's not their age. Maybe there's just somebody that we're leaving money to who's just not responsible, right? It might be, hey, my kids, I've got clients like their kids are in their late 20s, early 30s, early 40s, and it's just like a failure to launch type situation, right? They are not motivated. They're not really, good with money, whatever it is. And so they might want to leave the funds to their kids in trust with somebody else managing it. So the money's still there for the benefit of their kids or their nieces or their nephews or whoever. It's just that we're not going to give them direct access, right? Mike, the trustee, can use the money for their benefit, and we can kind of put whatever parameters in there as far as how we want them to use it. Do we want them to have, kind of broad discretion? And do we want them to be liberal? Do we want them to be conservative, et cetera? Everybody's got their own version. But there might be reasons why we would leave money to a beneficiary in trust that's maybe not just age related. Okay. And then definitely if we've got a beneficiary who's maybe they've got special needs, right? Maybe they're disabled in some fashion and they for sure can't manage it due to their disability. And in addition to that, they might be receiving benefits from the government where they can only have a certain amount of money in their name. And if they were to inherit this money outright, even if they did have the ability to manage the money on their own, if they were to inherit this money directly, it would kick them off of those benefits. And so there might be, the need to have their money go through a special needs trust for their benefit that can kind of come, work through the trust as well. So there's these options. We're not going to go down the path of special needs today, but just giving you an idea, different reasons why we might leave beneficiaries their funds in trust. Okay. And I see that there's a question, and I promise I'll get to it. I just want to finish my thought here. So, the most common scenario would be due to age, right? So I'm working with clients, and maybe it's a younger couple, younger-ish couple, right? And maybe their kids are, very young or younger, like mine. My kids are 5 and 8. Maybe their kids are 14 and 18. They're just not at a point where they want them to have the money yet. And so we might put parameters and say, everything goes to my two kids equally. But if they're under the age of, and I'll give you my example, if they're under the age of 30 when we pass away, then the money's going to go to them, and the $500,000 will get set up in two separate trusts, one for our son, one for our daughter. Uncle Mike will be the trustee, and he'll manage it for the kids, and he can use it. And I want to be very clear because some clients are like, well, I want them to have it at 18 so they can use it for college. And I'm always like, They can, but we want the trustee to use it for them for college. We don't want the kids to have direct access. So our trust says our kids can't have it until they're 30, but Uncle Mike can use the money for their benefit until they're 30. So if they need money to pay for college, he can pay for college. He can help pay to rent an apartment. He can help pay for a wedding. He can help them buy a car, travel, but it's his discretion. I always say, look at that trustee as like a surrogate parent from a financial standpoint only, right? If you were still alive and your kids needed money, they'd come to you and you would say yes or no. Well, now there's a trustee that's going to do that. And hopefully that trustee has similar values to you because you probably want your kids to be treated by that trustee just like you would. And so again, I want to be very clear. The money is there for their benefit. We're just saying they can't access it directly until they're 30, right? In a perfect world, our kids are over the age of 30 when we pass away, and the money goes directly to them. It doesn't have to go into a trust. Okay, so that's also how that works, right? That idea of that trust until they're 30 is only there as a default in case we pass away before they turn 30. Now, we also have to think about what happens if our beneficiaries don't survive us, right? Awful conversation to have with, young parents, maybe who just had their first kid, right? I'm dealing with a client who's like still in postpartum, and I'm asking, what if your child didn't survive you? Where would his or her share go? But we have to think about these things. So, in most cases, or in a lot of cases, we would say, well, if something happens to our son or our daughter, or our niece or a nephew, or maybe it's more common son or daughter, it would go to their kids if they had kids. Right now, that's not the case in every single situation. I'd probably say 90% of the time, 99% of the time, probably. If something happened to my son, it would go to his kids if he had kids. And if he didn't have kids, then everything would go to our daughter and vice versa. And we even have to account for what if my wife and I and our two kids were on a bus. I always use the example, we're on a bus tour in Peru and the bus falls off a cliff. Where does everything go? Because in that example, we don't have grandkids. Does it go to our brothers, our sisters, our nieces, our nephews? Is this where we all of a sudden get charitably inclined? So when we're planning, and when everything I'm talking about right now, I'm talking about it through the lens of a trust. We can do this through a will as well. I just want to obviously be very clear that this part kind of operates very similarly. Again, the will doesn't avoid probate, but as far as like naming beneficiaries and even having the ability for a trust to be set up, you can do that through a will. It's just that it ends up getting set up through the court, okay, through the probate process. Listen, I always when I plan with clients, my goal is always to over plan, right? I'm going to ask hard questions. And that's not to make people feel bad, but it's to make sure that we cover all our bases. And I'd rather obviously plan for all those things that we hope will never happen. We're fairly certain will never, ever happen, but I'd rather plan for it than not. Better to plan for something that doesn't happen than not plan for something that does. That's really how a trust works, in its most basic sense. Every time we create a trust, we have a will that goes with it. Okay. Now I want to be clear. In some cases, people just put a will together, right? That is their main planning tool. And that is, unless we just put beneficiaries in every single account we have, that's not going to be really a device to avoid probate. Right. So one planning tool is just to set up a last will and testament. But every situation where we create a trust, we always put a will together that goes with it. We refer to that will as a pour over will, like a pour over coffee. Okay. Pour over. The will is a very simple will. Okay. The trust has all the meat and potatoes in it, right? The trust talks about who gets our stuff when we die. How does it go to them? Where, what age do they get it? If they die, where does it go? All of that. Okay, the trust has all the guts. So the will is going to be a super simple will. We're going to name executors, and the executors of our will typically will match up with the trustees that we just named in our trust. The beneficiary of our will is going to be my trust. That's kind of the term, the phrase pour over. So the beneficiary of my will is the Matt Margolis trust. Okay. And then my trust has all the information regarding the beneficiaries, et cetera. And then if I have minor kids, so for those of us that have minor kids, the will is also where we name guardians, which I mentioned earlier. Okay. That is where we have to name guardians, right? Who will take care of my kids, our kids, my wife and I? Who will take care of our kids if, God forbid, our youngest doesn't survive or we don't survive our youngest turning 18? We can name as many people as guardians in order as we want. The reason for the pour of a will for those people that don't have minor children, okay, so they don't have the need for guardian. The reason for the pour of a will for everybody, there's just like an added reason for those with minor children, but the reason for the pour of a will for everybody is that, again, I used this example earlier, some people with trust will still go through probate because there's some attorneys that work like us that I think do a really good job where we take a lot of time to go through with our clients. And even though we like I said, we retitle the real estate, we go through all of their bank accounts and every single investment they have, and we tell them with very clear guidance what they need to do with each specific account, right? It's not like a broad list like, hey, with every bank account, you should do this. It's literally every single specific account. We're giving them specific directions. But we know that even with doing that, some of those clients still won't do it, unfortunately. We just know that. And then there's some attorneys out there that put trust together for people and don't give them any direction. I've had clients come to me where they did planning with an attorney, 10 years ago, 5 years ago, and now they're looking to update their documents and there's nothing in their trust. And they have no idea. Some of them now, some of them do. Some of them admit the attorney said we should do it. We didn't do it. And then some of them say, the attorney didn't tell me we needed to do anything. Got them. Thankfully, we're still here to make some changes. And now we know what to do. So if something were to go through probate, right? Let's say that some bank account slipped, or I always use the example, clients, they inherit a lake house from one of their parents, 20 years down the road after they do their planning. And the attorney handling the parents' estate just transfers the lake house to the son or to the daughter in their name only, right? The kids they forget to mention, oh, we have a trust. We should probably have it retitled to our trust. And then they don't come to me or another attorney once they have it and say, oh, hey, we just got this lake house. We should probably put it in our trust. And they pass away in the trust, the lake house is in their name. It goes through probate. So it's still going to go through the whole probate process, but that pour over will is going to kick in. And all it's going to say is, hey, judge, if you're reading this, two things happened. Number one, I died. Number two, something slipped through the cracks because I have a trust in place. And so at the end of this probate process, this piece of real estate is going to pour over into my trust. So you still go through the probate process, but it just ensures that whatever asset is going through probate ends up going into the trust, and then it gets distributed according to the terms of the trust. And I want to be clear that in these cases, it's not like if one thing goes through probate, every single asset has to go through probate along with it. It can just be that one asset that has to go through probate, whereas everything else can avoid probate. So I want to be very clear in that sense. So the pour over will, what I always tell clients, we look at this as like a safety net that I hope we never use. All right. Now, I want to talk about a situation where, in a lot of cases, a joint trust for a married couple makes sense. For married couples, let me explain it this way. For married couples that have an estate under $4 million in Illinois, $4 million is the estate tax limit in Illinois. So if a married couple has an estate that's not greater than $4 million, and they tend to own things jointly, right? All their real estate is joint, their bank accounts are joint, etc. Right? First marriage, maybe even a second marriage, but they own things jointly, then a joint trust would make sense. But if it's a married couple where they have an estate that's over $4 million, then it would make sense to have two trusts. Because I get a $4 million exemption, meaning I can pass on $4 million to my beneficiaries when I die tax-free as an Illinois resident. My wife can pass along $4 million tax-free as an Illinois resident. At my death, I can gift an unlimited amount of money to my wife tax-free. So if we have a $6 million estate, for example, we don't. I wish we did, but we don't. We had a $6 million estate and we had a joint trust. At my death, no issues. Okay. We could have a $20 million estate. I won't go there. $6 million estate goes to my wife. Okay. No taxes. But when she dies, she can only, I know, right? Nice problem to have. She can only pass on $4 million tax-free with this joint trust. So $4 million, no taxes. $2 million will be taxed. Okay. And let's just say that the rate is like give or take 10%, right? Ish. And that varies based on a number of different things, but just use the number 10%. That's a $200,000 tax bill. The way that we avoid that is actually pretty simple. What we do is we create two trusts, right? We have a Matt trust and a Christina trust. And we try to divide the estate. It doesn't need to be perfect, right? It's never going to be 3 and 3. It might be 3.5 and 2.5. It might be whatever, some version of that, right? So let's say it's 3 and 3 for sake of argument. When we do this, married couples are like, wait, so now there's going to be assets that we're going to have to move into my wife's trust that and then assets in my trust that I want them to be joint. Well, I get it. Here's the way it works. $3 million in my trust, $3 million of assets in my wife's trust. Even though we're splitting up the assets, and technically some are in her trust, some are in mine, we will be co-trustees of each. And so as co-trustees of each, we still have access to everything, right? So for all intents and purposes, it's still joint in that sense. We're just splitting it up for tax purposes, which makes a ton of sense. Because rather than paying that $200,000 tax bill, what's going to happen is when I pass away, even though my trust operated off my Social Security number during my lifetime, and we filed our taxes the same way, at my death, my trust will get a taxpayer ID number, an EIN, an employer identification number, right? It's almost like my trust becomes a business. And my wife will still have access to it. She can still access all the money, deal with it, use it for her benefit, but the money never gets added to her estate for tax purposes. It kind of stays in that bucket. And then at her passing, both trusts pass to our kids tax-free because her estate's still at 3 million, and then there was 3 million in my trust. Okay, very simple. I'm not going to go into any more detail than that, but like try to give you a very simple explanation as to why a true trust type of plan might make sense depending on an individual or a couple situation. And that will typically be for couples that for sure have over a $4 million estate. And then it could also be for couples that maybe it's a second or third marriage and they just don't commingle their assets. Well, in that case, we would do separate trusts as well, right? We're not going to all of a sudden say like, okay, now that you're coming to do some planning, we should just do a joint trust, right? Because they might want to leave their money to their kids from prior marriages, etc. So I just thought that would be helpful to mention. So there was a question that somebody had asked, what about a bank account titled as pay on death? Does that go through probate? It does not. Okay, so any kind of like payable on death, POD, or transfer on death, TOD, that's literally just like naming a beneficiary on something. Okay, so TOD, POD, beneficiary, all the same. Those will not go through probate. Okay, those will not go through probate. So good question. The one thing I actually want to throw out there that I really never recommend is this idea. I mean, and don't get me wrong, there can be situations where it makes sense. So I don't want to make a blanket statement, but I'm going to make a comment that in most cases, I don't like it. When people add their adult children as joint owners on their bank accounts or investment accounts or things of that nature. And the short thing I'll say, because I want to get finished and get through some other information here before our time's out, is that, let's say my clients add their daughter as a joint owner on the checking account that has $50,000 in it. And they do that because in their head, it's like a matter of convenience. If my daughter needs to pay bills or whatever, she can have access. But, of course, they have 2 kids, right? And their estate plan says everything goes to their 2 kids equally. Well, when my client dies, that bank account legally belongs to the daughter now, who is joint on it. Now, if daughter all of a sudden doesn't get along with her sister or her brother when mom dies, daughter doesn't have to split that account with her sister or brother, and she would not be doing anything wrong. So I just bring that up. Those things can get kind of messy. They might not be the greatest way to do things. There might be other ways to do it. I can almost guarantee you there are other ways to do it. Now, if it's an account with like $1,000 or $2,000, I'm probably not going to make a big deal out of it. Okay, totally different. Definitely depend. Circumstance dependent, we'll say. But in general, that's not something I like to do. And definitely don't be adding your kids on the title to your house. Nobody. Definitely don't do that. Okay. If you want to know why, you can email me about it. I'm not going to go into that, but don't do that. All right. The last few things we'll talk about here, right? So we talked about wills, we talked about trusts. Whenever we're looking at sort of like a traditional estate plan, we look at a few other documents. So we look at powers of attorney for healthcare, property, HIPAAs, and living wills. All right. So in Illinois, we have 2 different types of powers of attorney. Okay, we have a healthcare power of attorney and a property power of attorney. Healthcare power of attorney is where we're naming somebody to make medical decisions for us in the situation where we cannot make our own. Okay, we can name as many people as we want on our healthcare power of attorney, but we're naming them one at a time. We cannot name them together. You cannot name co-agents. So the person I name on my power of attorney is called my agent. You cannot name co-agents on a power of attorney in Illinois. It is not allowed. I just had a client come to me recently where the attorney did that, and it was an Illinois document. I was dumbfounded. Some states do allow it. Okay. For medical, I think it's not a great idea to be naming for those states that allow two people to be named. The last thing we want are two people to be arguing over what to do in a, maybe a pretty serious situation where somebody really needs to make a decision. But we don't have to worry about that in Illinois. Illinois, we can name 5 people, but they're named one at a time in succession. The reason that we would put a power of attorney for healthcare together is that we want to avoid a guardianship. So in Illinois, a guardianship is a process where if I don't have a power of attorney for healthcare, same thing for property, which we'll get into in a second. But if I don't have a power of attorney for healthcare, and I'm incapacitated now, and now I cannot make my own decisions, then somebody needs to hire a lawyer and petition a court to now be my legal guardian. And that can take time and for sure cost money. And now you might have to, the guardian might have to check in with the court, depending on certain things the guardian might want to do for me, because now the court is overseeing it. So this can become a more expensive process for sure, a more timely process, and something that's just not ideal, right? I don't want to be checking in with a court when it comes to making decisions for my wife or my mom or my dad or whoever it is. And I know none of you do either. So number one, we're doing it to avoid guardianship. Number two, we're doing it because we want to have control over the people that we're naming that will step in to make medical decisions for us. Because if I don't put a power of attorney together, I can't decide who my guardian will be. Maybe I've got 2 kids that I'm estranged from, and one of them decides, they want to be my guardian. Okay, so I have control over who I'm naming, but then also I want to make sure that I'm talking and I'm communicating to people that I'm naming, and I let them know what I would want them to do in a serious situation, right? Do I value the quality of my life more than the quantity? Do I value the quantity of my life more than the quality? You want to make sure that you're naming people that are comfortable making your decision for you, right? Not their decision, right? It shouldn't be their decision. It should just be them stepping in to make the same decision that you would have made if you were able to make your own decision. And that's sometimes very hard. I've got clients that think that, oh yeah, my daughter is great. She's so loving. She's a nurse. She's wonderful. She'll be my power of attorney. And then 3 weeks later, we're sitting down and they're like, nope, not going to happen. Our daughter said she can't pull the plug, and that's what we want, right? We want quality of life over quantity. So these are just important things, right? We want to make sure that we're picking the right people. We should really take some time when we're doing this. We should talk to the people that we're naming to make sure that they're comfortable stepping in to make these decisions for us. So the other power of attorney is what we call a property power of attorney. Now I say property power of attorney, and so many clients are like, well, I don't own real estate. I just rent an apartment. I don't need a property power of attorney. Well, a property power of attorney is really naming somebody to step in to make all those decisions that are not medical in nature. And if you have a trust, not regarding any assets that are in the trust, because that will be your trustee that will manage those assets in the trust. So your property power of attorney could deal with real estate, right? If you don't have a trust in place, then they would deal with your real estate. But your property power of attorney would deal with things like your life insurance policy, because that's going to stay in your name, even if you have a trust. Your IRA or your 401k, that'll still be in your name. If you're incapacitated, your property power of attorney will handle those on your behalf. Your property power of attorney, if you're incapacitated, will file your tax return. Will deal with issues with Medicare, with Social Security. Will apply for Medicaid if you need it. Will sign a contract with a caregiver if you need a caregiver in the home now. Your property power of attorney really steps in to become you for all things that are non-medical. Similar to the healthcare, you can name as many people as you want. You're naming them one at a time in succession. And again, if you don't have a property power of attorney and you are incapacitated, somebody will have to petition the court to be your guardian. Okay. I would say, as important as wills and trusts are, powers of attorney are something that everybody should have in place. I mean, everybody should have a will or a trust too. Don't get me wrong. Okay. But powers of attorney are so important to have. Okay. So important to have. And yeah, that's all I'll say. Make sure, everybody that's on this call right now should have a power of attorney. If you don't, get one. Okay. Whether it's through me or somebody else, I don't care, but get powers of attorney in place. I mean, like I said earlier on this call, we had an influx of clients that we'd worked with, and maybe some people that weren't even clients, who brought their 18-year-olds going off to college in this summer and getting powers of attorney in place for them. So, because colleges can't talk to parents regarding their kids, anything that's going on with their kids, because they're over the age of 18, they're adults now. Um, if there's anything going on with like tuition or anything like that, and something happens with the kid and they're incapacitated or whatever, cannot discuss it without going through a guardianship in those situations. So, you know, for those of you that have kids going off to college or that are in college or you have grandkids that are in college, this is something important. It's something that should be, discussed more. Um, so we have powers of attorney for healthcare property. And then the last two documents are the HIPAA and the living will. The HIPAA is the healthcare authorization, right? You probably signed a HIPAA before, maybe at your doctor's office at the hospital, somewhere where you're saying you're basically giving permission for one medical institution, maybe to pass your records on to another. Well, we have clients sign HIPAAs giving access to individuals simply to have access to their medical information. There's no specific order on my HIPAA. So my HIPAA, I've got my wife, my parents, my siblings, my in-laws, right? Doesn't matter if my wife is technically named on their first or last. Anybody that's named on my HIPAA can really do one of two things. They can go to my doctor and ask for copies of my medical records if they really want to. I don't think any of them would really care to do that, but they could. And I have to be comfortable that they could do that. The other thing about the HIPAA, and the reason that I really like it, is if there's an emergency and I'm in the hospital and I can't, communicate to give permission for anybody to know what's going on, anybody on my HIPAA can call the hospital, go to the hospital, talk to the doctors, talk to the nurses, talk to the staff, find out what's going on with me. Right. And I like this because in that type of situation, I wouldn't want everybody to have to like bombard my wife and get the information through her. Right. My parents could get it from the hospital directly, my in-laws, my siblings, etc. And to be very clear, the HIPAA gives access to information. It does not give decision-making authority. Okay, that's the healthcare power of attorney. And this is a very important distinction because my healthcare power of attorney, I named my wife and like two other people. But my HIPAA has like those three people plus another five. So there's clearly five people that I am more than happy to have them get information about what's going on, but I just don't want them to be making medical decisions for me. Okay. And then the last document is the living will. The living will is not appropriate for everybody. For a lot of people, it is. Okay. The living will is the do not keep me alive unnecessarily document. This is not the same as a DNR or what's now called a POLST, POLST, practitioner's order for life-sustaining treatment. So POLST and DNR, sort of the same document. If you hear either one of those, terms or phrases, it's the same document. That is a doctor's order. That is a practitioner's order. Exactly what it sounds like, right? Where you're saying you get to make a couple choices. You get to say yes or no to being resuscitated, right? No pulse, no breathing. Do I want to be resuscitated? Yes or no? How do I feel about end of life decisions? Just do what you can to keep me comfortable, or do a little bit, but not everything, or do everything you can. I don't care. I'm gonna have zero quality of life. Do whatever you can to keep me alive. Hook me up to machines, etc. You get to choose one of those three. And then the last one, you get to make a decision as to how you feel about artificial feeding. Okay. Now, that's not a legal document in the sense that you don't go to a lawyer to put that together. Okay. It has to be signed by a medical practitioner. It has to be signed by either a doctor or a physician's assistant. I think it's like an RN and then like a first or second year resident. There's like 4 or 5 different medical professionals, but it has to be signed off by one of them. If you're interested in that document, I suggest talking to your doctor about it, and he or she can kind of give you some direction. I will tell you right now that a lot of doctors will not sign off on it for my clients that are, especially for those clients that are like in their 60s or 70s or maybe even early 80s. People don't realize you could have a heart attack and not have a pulse and not be breathing. Most of us would want to be resuscitated from that. Now, somebody that's 90, 93, 94 has a heart attack, a doctor might say, that's okay. You might not want to be resuscitated. There might be more bad than good that comes from that. So again, every situation is different. If it's something you think you have strong feelings about, have that conversation with your doctor, or maybe they'll sit you down with the nurse or the physician's assistant. These days, spending that kind of time with a doctor can be difficult, but have that conversation if you think it's something you want to do. The living will is not as controlling as a POLST in the sense that, I always use the example. So the living will, by the way, says, I value the quality of my life over the quantity. Do what you can to keep me alive, but don't use extreme measures. It's not what I want. So for those clients of mine that value quality over quantity, they'll sign it. But I have certain clients that maybe for religious reasons, maybe for other reasons, they want their life prolonged to the greatest extent possible, then they're not going to sign a living will. And this is the last example. I'll leave you with this example. And then, I know we're a little bit past the hour mark, and I'm sorry about that, but glad most of you stuck with me. The idea, here's how I compare a living will and a POLST or a DNR. Paramedics come into my house and I'm laying on the ground and my DNR just happens to be laying on my chest. And it says, I don't want to be resuscitated. Well, if I have no pulse and not breathing, they're not going to resuscitate me. Okay. Same set of facts, right? I'm laying on the ground, I'm unconscious, and paramedics come in, and my living will happens to be laying on my chest. They are going to rip that living will off of me and try to bring me back to life. Okay, that living will is not going to, it does not say do not resuscitate. Okay, that is not what it is. It is more direction to my healthcare power of attorney that I do not want my life artificially prolonged. Okay, so I just want to be very clear as to what those documents are. All right, it's 10:17. We're 2 minutes past. I don't know the timing that Amy has and the YMCA has. If there's another talk right after me, I can probably hang out here for a couple minutes. If people have questions, if you want to unmute yourself, I'm happy to, take a couple questions, but I don't have too much time. I've probably got about 6 or 7 minutes.
Yeah, we're good on my end for a couple questions.
And thank you for everybody's attention. I appreciate it. And I'm because I can't get into the chat box easily, I'm going to email like a nice block of my contact information to give to Amy, and maybe Amy can copy and paste it into the chat box.
Yeah, I sure can.
Of course, anybody can reach out to me if you have any questions, you ever want to discuss something. I mean, that's not why I do these, but obviously, if you have those questions or you have any interest, we're happy to help. So I think that goes without saying.
I have a question on
Yes.
If you have a bank account set up on payable on death, does that go into probate or not?
It does not. It does not.
It does not. Okay. All right. I thought so, but I just want to clarify that. Thank you.
Yep. Yep, of course.
Oh, okay. Well, that's kind of a broad question. Okay. Well, all right, I suppose.
You have any questions there, Gloria?
Yeah. How does having individual trusts, how does that get impacted if someone is forced to go on to Medicaid? I mean, so if, let's say, we both have our own trust, my husband, let's say, he's liquidated his trust. Now he needs to apply for Medicaid. Are they going to look to my trust to meet the financial requirement to be eligible?
That is a fantastic question. And the short answer is that whether you have those assets in a trust or not, Gloria, the Medicaid looks at a married couple together. And so, yes, they will, those assets that are in that other spouse's trust or not trust, it really doesn't matter, to be honest with you. Those would be part of the equation when applying for Medicaid. Yeah, they would be on the table, so to speak. Now it can depend on the type of trust, and I don't want to I can't go down a rabbit hole here and kind of go real in any real detail. There are certain types of trusts where the money could be off limits, but that would typically have to be done where it's an irrevocable trust where it was set up for asset protection, and the money was in that trust for a long enough period of time where it would be by the time Medicaid is being applied for, it wouldn't be part of the equation. So happy to discuss that offline if it's something you're interested in. We can go into a little more detail, but it's a great question. And yes, the answer is unfortunately, yes, Medicaid would, even if I'm the one applying for Medicaid and my wife and I have separate trusts and mine is now, depleted to the point where, I have the amount of money in my name where I'm Medicaid eligible. Okay. We use that phrase. They will still look at my wife to see what she has, and whether it's in her name again, individually, or whether it's in a trust, they will want to know what she has, because she's only allowed to have a certain amount when I apply for Medicaid. So good, really good question. Really good question. Mary had a question. First of all, Mary, I appreciate your comment. Amy passed along to me. That was very sweet of you. Can real estate be titled transfer on death? So yes, my short answer is that there is, I normally don't go deep into this. There is something called a transfer on death instrument in Illinois. Okay, so it's something that we prepare. We can record it with the county. It is a way to name beneficiaries on a house without creating a trust. I would say that in a lot of cases, going the trust route tends to make more sense based on, at least for our office, based on what the fees are for everything. It might be slightly more to create a trust, but then we're able to put real estate in it, and we can put bank accounts in it, and we can put all the investment accounts in it. And so it kind of really handles everything all together. And again, depending on how we want that real estate, who we want that real estate to go to, the transfer on death may or may not be a great solution. So even though it can avoid probate, it may not be the right solution based on, you know, who we want the real estate to go to. So I hope that's helpful. So the answer is yes, but, you know, kind of with like an asterisk, very situationally dependent or situational dependent. That makes sense.
Okay, if there aren't any other questions, I'd be happy to email everybody Matt's contact information that was here on the chat today, if that's all right with you, Matt.
Yeah, of course.
Okay, great. And I just want to thank you on behalf of the North Suburban YMCA. This has been a wonderful chat. I learned, I feel like everyone else learned and took away something as well. So we thank you for your time.
Yeah, well, thank you all. And thank you, Amy. I appreciate it.
Have a great day, guys.
Bye, everybody.